So next I'm going to tackle this, there's some presentations for petitions discussion from the 1800s. Here we've got 1844, but it's referring to Standing Order 1840. But there's also another source that's referred to something 1842 as well I've got to look at. But just for the sake of the actual time that this is happening now, and when I found this, we've got that Julian Assange hearing that's just been, and I've got a complaint to the Judicial Conduct's Office about Julian Assange's hearing, and I've submitted a petition for his release, and I found something in here that is actually relevant to that. So I'll just go into it now, because you can actually petition about criminal matters. They've been lying to us. I mean, we've got the John Pym evidence from Parliament that you can, and Richard Tyson said they've even been doing it more recently, putting motions through to get convictions overturned. So I'll just read from this, because this is really relevant now for Julian Assange's situation. Although officially, when I searched the Parliament website, there weren't any petitions, and I know I submitted mine. There might be other ones that they hadn't published, but they hadn't rejected any. I know that independent people are doing them on like change.org, 38 Degrees, and Robert F. Kennedy Jr.'s got one, and just obviously through verbally making themselves heard outside the courts. So I'll just read this. This is really interesting. So the presentation of petitions. This is the 2nd of February 1844. Mr. Wallace said that before bringing forward the motion of which he had given notice, so he'd already given for rescinding the standing order which prevented any discussion on the presentation of petitions. Obviously, that does not mean that they hadn't given notice of them. So there were some standing orders concerning petitions in 1844. At the moment, I know we've got this Standing Order 145A, which is how the Petition Committee itself operates. But then there are other ones to do with how they're presented and, dealt with in Parliament, which is separate. But listen to this, right? He wished to have that standing order read. So he wanted to have this standing order read. The Standing Order of 1840. But that's not 1840. There's meant to be something for 1842 that I want to look at as well. But this is in 1844 when this is happening. So he's referring back in 1844, they're speaking about the Standing Order of 1840. It was then read. It enacted. So this is also confirming that standing orders have been enacted. That no member, on presenting a petition, should do more than state its general substance. Well, that does not mean to say, right, that in no way, that is in no way to say that the petition itself does not have great substance and detail, and is not allowed to have great That is not to say that petitions themselves cannot and do not have a great substance. It is merely here saying that when they are read out in Parliament, they have to just be summarised. The MP needs to summarise them to the House. Otherwise, you've got like when Andrew Bridgen goes into Parliament, and he's got 8 or 9 sheets of paper, which take him the best part of 15 minutes to go through, or half an hour, and no one turns up. That that is like an actual debate. That you're actually into the debate in full. Then, when the petitions are presented and read out, you're just basically giving a brief. You're just briefing them on them. And unfortunately, I think that has been adopted by the Petitions Committee for the full writ of the online petitions basis, that, they're wanting you to just summarise your petition and not even submit any evidence or facts or really much. And that's a shame, really, because what they're doing is the ability to actually submit a case to Parliament for something to prove or justify something, which the substance is mandatory, then that is completely separate and different from when it comes to mentioning them in the House. And you just summarise them. They're basically effectively having the petition become, it's almost like what they were supposed to, read out in the House when they refer and mention the petition, not even getting to debating it. It is actually been now made as what the petition itself is. So when you get to debating it, I mean, what is there? There is nothing, because, they've reduced it to nothing, unless they do these special processes when they call everyone in, when you get a special tea party with them and, you get to divulge. But then how have you proved, I mean, if you've got investigation work or other facts that are legally bound to the whole affair, what evidence have you got of that if you can't submit it and it's not officially logged? That's ridiculous. It's almost kind of like, can you imagine if you had a very, very important criminal case in a Crown Court or in the High Court, and they said, how would you prove the case? It was almost like, no, just basically summarise it and brief it as much as you can, and submit it to the court, and then, but that's the thing. You're meant to, you don't do that. I mean, that's what the listings are on the court, the name and the case number, and they don't tell you what the case is about, really. It's meant to be confidential, isn't it? All the newspapers do report what charges are. They brief it. It's almost like the newspaper, isn't it? The newspaper, says like, 3 people have been arrested on suspicion of whatever. It's almost kind of like, I would say that, what's in the newspaper is what they are allowed to tell you in the newspaper, what it's about, and how many people are involved. It is more than what they list on the court listings, that's not the entirety of the case, or else it would be kind of like, the entirety of the case is what they publish in the newspaper, which is the briefing. What they read out in Parliament, basically, what the petition's about, when they brief them on it, it is effectively the same as what the newspaper's allowed to say, essentially, but that's not the full substance of it, or else you don't have anything, do you? But that's not the point that I wanted to get to in here. It says, she states general substance that no discussion should be allowed on such presentation, but that if the petition related to a matter on which a member intended to found a motion, he might move to have it printed with the votes he giving at the time notice of such motion. From this rule were exempted, so this is when it doesn't apply, petitions complaining of a grievance, any delay in the notice of which may be injurious to the public or to individuals. So important and serious or immediate matters are exempt from that rule, so they can be addressed in full and extensively. Injuries to the public or to individuals. Well, what happens if to none we will deny, to none we will delay right or justice? Well, what about these criminal matters, or particularly if people have been prosecuted unlawfully and so forth, and they're having their rights delayed, like Julian Assange has been detained without trial? That's injurious to him because he's suffering legal injury. So the Assange petitions really about an individual being injurious to him. So, and the public are outside being concerned, and also there are a lot of what about all the ULEZ cameras being cut down? Shouldn't those petitions be urgently read out in full and so forth? They would be exempted from the kind of briefing restrictions. They would be exempt from it. And in fact, what's happened is Parliament itself, the Petitions Committee, the current one, won't even let you submit petitions that are a grievance, really. They say that, wrongdoing. They won't let you publish any about any wrongdoing, any members of Parliament or any wrongdoing anywhere, really, which is ridiculous because here, grievances as well as changes in law. So I think the ones that are shortened down and briefed are the ones when people were wanting to get the new laws made or the law changed or something to do with, departmental or whatever. But there are exemptions here when it is a grievance or complaining about things that are urgent or involve individuals or the public injurious. Well, that's happening now with you, Les. And it's also happening with Julian Assange. And you could say, about Tess Lawrie when we're all having his rights threatened to be taken away by the World Health Organization and things like that. So there is an exemption to it. Unfortunately, they're blocking them completely. It's not really fit for purpose, the electronic system. In fact, I went on the small claims court, and you can add evidence, but you can't upload files for some reason. There's there's a number of separate fields to enter quite a bit of evidence. I don't know if you to put links in there. I suppose you could put Google Drive links and things like that, or links to websites, but there isn't a upload. I didn't see an upload file, but there's lots of separate fields to write lots of information in each piece of evidence. I suppose you can put witnesses in there and things like that. So this Julian Assange matter, really, I've entered a petition for it, and it is urgent. And I've got a lawful right for that, and I've got a feeling that they're going to reject it, although I've collected 5 signatures on it now, so it should be getting looked at. But I've got a feeling they're going to reject it, so I've complained already to the Judicial Conduct Investigations Office, and you can complain about the Petitions Committee because you've got representations with the House of Commons from the High Court, which is a link between, and it includes the Petitions Committee, and as the Petitions Committee have got powers or some sort of power, like a chairman does the Justice of the Peace and a commission, even the council, even the chairman of the council is a Justice of the Peace for the commission of the council, but not for a court. You can complain about the Petitions Committee to the Judicial Conduct Investigations Office through representations to Parliament. So I'm complaining that, they're rejecting. They can't actually reject them. This is the thing that I'm getting onto now. In the last video, I said, how far and how fit they are to be received, but that was a resolution because of the 1661 with the other bodies that were involved. That was a resolution, so Parliament has a right to receive them from the other bodies. But then, the 1688 one resolves the whole thing, because you can't be held to any commitments at all or prosecuted. So, they don't have, they can't say they're unfit or how far they're to be received, because how far, well, you got the right to petition for the King to, for the House of Lords to ultimately, all the way, this is the thing. How far from the 1661 Act, how far could it go? Well, you had the right to go to Parliament, but clearly they weren't getting there, some of them, so they had to have a resolution. And then, how far does it go? You got the right to, ultimately, everyone's pursuing it, put him through both houses, aren't they? So, he's pursuant of getting approved by the King. That's the basis of it. So you've got the right to lodge it. You've got the right to submit to lay it. Whether or not they act on it or not, or whether or not it gets put through or actioned is separate. But you've got the right to submit it. And what they're doing is they're making these standards up which aren't the standards back when it was fit or unfit is to do with back then not a lot of people could read or write, and they just put scribbles and marks and so forth on and things like that. It's a lot different now. Everyone can read and write, so there might be some silly petitions, but then again, look at the Monster-Raven Looney Party. It's an official party and they run for council in elections, and they're still managing to do silly things, so injurious to the public or to individuals, in delaying the notice of which might be injurious to the public or to individuals, or injurious to injure them. Well, that's interesting because in various acts we've got when you're using the Town and Country Planning Act to put up political materials, it says that you're not liable to any danger or risk of danger that is left. So but that's only the petitioner. That's removing any legal liability against the petitioner. But that's not to say whether it is injurious onto the public or not. It just says they're not liable for it. That they're not prosecutable for it. That's a legal liability. That's nothing to do with the petition content or what if the public do get injured or not. So they were also exempted from the rule petitions against measures imposing direct taxation. They were also exempted from the rule petitions against measures imposing direct taxation. The honourable member went on to say that the motion with which he should conclude would be that the standing order just read should be rescinded. As the question had occupied the attention of the House on 2 former occasions, it was not his intention to enter at any length into it, for the importance of having the petitions of the people received and discussed in that House was so obvious that he could not see on what reasonable ground the practice could be set aside. During the period he had served in Parliament since the year 1833, for 2 years of that period, 1833 and 1834, the petitions of the people were discussed at the time of their presentation, and that diffused great satisfaction generally throughout the country. The discontinuance of the practice had produced the reverse result, having led to general disappointment among the people. Petitions were now laid upon the table and afterwards jammed into bags and sacks as if they were of no importance whatsoever. Those who knew the consideration which the people attached to getting up their petitions, the respectful and careful manner in which they were worded, and the great interest which they took in them, should take counsel themselves before they gave a vote on the continuance of this obnoxious practice. He had no hesitation in admitting that a considerable degree of inconvenience was felt by the House at the time he alluded to, when discussions upon petitions were generally on all questions. At the same time, he was prepared to say that he ought to be and might be a distinction which could easily laid down in order to do away with the present system. He found that in the year 1839 division took place in this subject, with the numbers of 105 against and the renewal of the practice, and 50 for it. In the year 1842 this question was again brought before the House twice, on one occasion by himself, and then the division was 43 and the motion 103 against it. Similar motion was made by the honourable member of Finsbury. So I'm going to study this and come back to it, but there are a number of other things as well that have also come to my attention. So another thing we need to remember is that they actually had a committee anyway. So they must have had that committee still in the 1800s. When they were doing all that about reading them out and presenting them for debate and so forth, they still had a committee. They still actually had a committee. They had a committee for motions of griefs and petitions. It was established in 1571. So that's even before the Civil War. Might even go back as far as when they had the Lord of the Articles or Lord of the Rolls and so forth. That committee was even in place through the Civil War, although they had some other committees that were looking at petitions to do with certain investigations that we were doing in regarding, Bedford, Essex, that Painted Chamber Committee. I think that Painted Chamber Committee was a separate one. I don't know if it was, I think it was separate from this Committee of Motions and Griefs and Petitions when they were wanting to have other matters looked at. But this committee lived out its days uncontroversially enough and died a quiet death in 1974. So they did have a Committee of Motions and Griefs for Petitions from 1571 all the way through to 1974. Now, that Tumultuous Petitioning Act was in effect most of that time until 1986. So what was happening in 1974? Leading up to 1974, while it was still in place, that means that the 1960s are a very, very, very interesting period because we have the Tumultuous Petitioning Act, which was still there, not repealed, when you've got these other bodies involved. But then you've still got the actual Committee of Motions and Griefs. So let's look at the 1960s. So the 1960s, this is a time when the Beatles were big, would be a very interesting time for petitions if people were doing them and knew about them. A lot less books around then and a lot less research available than there is now, unless you're an expert, a specialist in, university, really, I suppose. Now, what I need to know about the 1960s is that you've got this... the Petition Election Rules 1960, and that sets out that for elections to Parliament, petition, they call it petition, a petition for an election to Parliament, if there are any criminal offences, frauds concerning those affairs and events, they weren't prosecuted at common law, they had to be prosecuted in the High Court. And some of them, some persons involved had immunity and they did get a fine, but they couldn't be criminally prosecuted. I think they might have changed it, but that would mean that on the basis of it's illegal to be prosecuted, but they were kind of fining them. I think they changed it to imprisonment later, but I'm not sure on what basis, but I know that they weren't prosecuted at common law. I know that for certain, and it was dealt with in the High Court. And in the but we've also got this representation of the People's Act as well. Now, so therefore, I think that a good place to research really is the 1960s for some sort of evidence without having to go really far back in Kew Gardens with all these hundreds courts and all this complicated King's Bench and all these other matters, because it's a more recent time, there's a lot more records. So we really want to see the records, Committee of Motions of Grief and Petitions and what people were petitioning about, if they were doing any investigation work, if they were submitting evidence, if they were getting called into Parliament, and if they were directing proceedings, and if there were ongoing proceedings, work being done outside Parliament in connection with these motions and griefs, people giving directions, Parliament subpoenaing stuff, calling witnesses, and so forth on this Committee of Motions and Griefs. And if anybody needed to use that immunity. But the other thing is that if it was a small number of people or just one or two people doing petitions, they would be doing it directly to the Committee of Motions and Griefs. If it was over 20 persons, could have been that they had these other bodies dealing with it. If it was 50 or 100 people, could have been that they were still having these other bodies involved in that process, like in the Tumultuous Act. and they've got justices or a large part of a grand jury and so forth. So there should be court records in the 1960s if anyone was using that process. How were the petitions getting evaluated or looked at if there's over 20 people before they're passed on to motions and griefs? And are they officially saying, right,